Priya and Daniel keep a shoebox under their bed, and it is the most important thing they own. Inside it is their marriage, or rather the proof of it. Photographs from a trip to the coast, a lease with both their names, bank statements from an account they opened together, cards they wrote each other before any of this was about immigration. Daniel is a U.S. citizen, a high school music teacher from Ohio. Priya came from Chennai, in India, on a student visa and never expected to fall in love in a language lab. Now they are married, and that shoebox is being assembled for a stranger, an officer who will decide whether what they have is real enough. If you are watching this, some version of that shoebox is probably in your life too. Maybe you just got married and the process is ahead of you. Maybe you are staring at a 2-year card and wondering what happens when it expires. Either way, this is for you. You are watching the expert guide from the law offices of Chris M. Ingram. Every week, we take one part of the United States immigration system and make it clear enough to act on. No jargon left unexplained, no fear left unaddressed. This week, it is the marriage-based green card, the most common path to permanent residence there is, and here is the promise. By the end, you will understand what that shoebox is really proving, why the 2-year card exists, and what you must do before it expires, and the single mistake at the very start that can follow a couple through every application they ever file. A quick note before we go on. This is general educational information, not legal advice for your specific situation. We've put the questions and timestamps on screen so you can jump to what matters most.
Just a quick reminder, if you appreciate this kind of in-depth content, please take a moment to like and subscribe. It helps us bring you more content. Now, on with the video.
Here is the thing to understand first, because it changes how you see every step. The government is not testing whether you love each other, it is testing whether your marriage is real. Those are not the same thing, and the difference is the whole game. A marriage can be full of genuine love and still be documented so poorly that it looks like nothing. And the officer cannot see inside your relationship, they can only see what is in the file. So the entire process is really about translating a real life into evidence a stranger can evaluate. Start with who you are married to because it sets your timeline. If you are married to a US citizen, your spouse is what the law calls an immediate relative. That means no annual cap and no waiting line for a visa number. The moment the petition is approved, a number is available, and your only wait is processing time. If you are married to a lawful permanent resident, a green card holder rather than a citizen, you fall into a family preference category that is capped, and there can be a wait. Becoming a citizen, when you are eligible, erases that wait entirely. Then there is the question of where the immigrant spouse is standing. If they are already inside the United States in valid status, the path is usually adjustment of status, filing to get the green card without leaving the country. If they are abroad, the path is consular processing, finishing the case at a US embassy. Same destination, 2 different roads, and which one you are on shapes everything that follows. As attorney Chris M. Ingram frames it for the couples the firm works with, the marriage green card is genuinely manageable once you understand what the officer is actually looking for. They are not trying to make your life difficult. They are trying to confirm the marriage is real. Once a couple sees the process that way, most of the fear drains out of it, and what is left is simply the work of documenting a life.
Now the part that catches more couples off guard than anything else in the process. If your marriage is less than 2 years old on the day the green card is approved, you do not get the 10-year card. You get a conditional card, good for 2 years. Hear this clearly, because it matters. That conditional card is not a lesser status. It carries the same right to work, the same right to travel, the same protections as any green card. But it comes with a string attached, and the string has a deadline. In the 90 days before that 2-year card expires, the couple must file together to remove the conditions, not after it expires. Before, that filing is where the shoebox comes back out, because it asks the couple to prove the marriage is still real and still ongoing. The joint accounts that have grown over 2 years, the shared lease, the life visibly lived together, miss that 90-day window or fail to file at all, and the consequence is severe. It is not a delay. It is the loss of permanent resident status, and if life has taken a harder turn, if the couple has divorced or separated by the time that filing is due, there are waivers available in specific circumstances. That is a road the firm has walked with many people, and it is walkable, but the deadline itself is not flexible. And the single most important thing a conditional resident can do is know exactly when their window opens and closes.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Let's answer the questions that are actually keeping you up in the order you actually ask them. First, my spouse came here on a tourist visa and we married while they were here. Can they get the green card from inside the country? Sometimes, and this is the most dangerous question in the whole topic, so hear it carefully. The problem is intent at the moment of entry. A visitor visa is for visiting. If someone enters on a tourist visa already planning to marry and stay, that can be treated as misrepresentation. And misrepresentation is a shadow that can follow a person through every future application. If the relationship genuinely developed after entry, the picture is very different. This is precisely the situation to take to a qualified attorney before filing anything never after. Second, what actually happens at the interview? Both spouses usually attend together at a local office. The officer reviews the file and asks about your life, how you met, how the relationship grew, the ordinary texture of living together. The most common problem is not dishonesty. It is inconsistency. Two people who never sat down and thought about the small details of their shared daily life giving answers that do not quite line up. Preparation is not memorizing a script. It is knowing your own life well enough to speak about it naturally. Third, how long will this take? For the spouse of a citizen filing from inside the country, the wait from filing to interview runs a broad range under current processing times, and it changes. While it is pending, the immigrant spouse can file for a work permit and for travel permission alongside the main application. Those usually arrive well before the green card itself. One hard rule though, do not leave the country while the case is pending until that travel permission is approved and in hand. Leaving without it can be treated as abandoning the whole application. Fourth, we live apart for work. Does that sink us? Not by itself. The law looks at the whole picture of a genuine marriage, not a rigid checklist of one shared address. Couples who live apart for real, documented reasons, a job in another city, school, caring for a family member, can and do succeed. The key is documenting why and showing the commitment continuing across the distance. Fifth, what if we are married to a green card holder, not a citizen? Then you are in a capped category with a possible wait, rather than the no-wait immediate relative path. If the citizen route becomes available through naturalization, it can change the timeline completely. That is a calculation worth doing early, not late.
Here is what many couples never realize until someone tells them. The marriage green card is not always the fastest or the only door, and a few situations call for a different one entirely. If you are a U.S. citizen and you are not yet married, but you intend to be, there is a visa built for exactly that, the Fiance visa. It brings your intended partner to the United States specifically to marry within a set window, after which they adjust status. For couples who are not yet married and want to do this transparently and correctly from the start, it is often the right door, and it avoids the tourist visa trap entirely. And if you are a lawful permanent resident whose spouse is in the capped preference category, the most powerful move on the board may be your own naturalization. The moment you become a citizen, your spouse jumps to immediate relative status, and the waiting line simply disappears. For a green card holder close to eligibility, starting that process can be faster than waiting for the preference date to move. As attorney Chris M. Ingram often puts it, the marriage green card is usually the right path. But the worst outcome is a couple grinding through the hard version of a process when a cleaner door was open the whole time. That assessment is worth getting from someone who does this every day before you file.
So picture Priya and Daniel again, the shoebox open on the bed, sorting photographs into some kind of order. Here is what changes when they understand what they are holding. The box is no longer a nervous ritual. It is evidence, assembled with intention, that translates a real marriage into a form an officer can evaluate. They know now that the citizen spouse path means no waiting line. They know the 2-year card is coming because their marriage is young. And they already know the 90-day window they will need to hit 2 years from now. They know the interview is about knowing their own life, not performing it. And they know that the one thing they must never do is leave the country while the case is pending without permission in hand. The shoebox is still under the bed, but it is not a source of dread anymore. It is just the proof of an ordinary, real life being put in order. If you are somewhere on this same road, the most valuable thing you can do is get your own situation assessed by people who guide couples through this every day and who know exactly where good marriages get tripped up by bad paperwork. The law offices of Chris M. Ingram has walked binational couples through this process for more than 2 decades. Visit breakthroughusa.com to find out where you actually stand.
Before you go, one question, and keep it general in the comments. No personal details. Which surprised you more? That the officer is testing whether your marriage is real rather than whether you love each other? Or that the 2-year card comes with a deadline you have to hit years later? We read them, and we build episodes around the answers. Here is where we are headed next week. Priya and Daniel will get their approval, but because their marriage is young, the card they receive will be the 2-year conditional one, and the clock on that 90-day window will start ticking the day it is issued. Next time on the Expert Guide, we open up that conditional card completely. How to remove the conditions, what the evidence has to show after 2 years of marriage, and what happens when life does not go according to plan. Because getting the card is not the finish line, keeping it is. You have got this. We will see you next week. This has been general educational information, not legal advice. For guidance on your own situation, speak with a qualified immigration attorney.